This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant, expert witness, author, and producer of these videos. Today I'd like to speak about the need for an additional insured provision in a contract of insurance dealing with construction or construction defects. Additional insured provisions include such information as, quote, the owner shall not require the contractor to include the owner, architect, or other person or entities as additional insureds on the contractor's liability insurance. Sometimes, on the other hand, they do require such additional insured provisions as a means of transferring the risk of loss. Although the additional insured requirement provides additional security to the owner and architect, it can, and usually does, add to the cost of insurance. Regardless, the requirement is often included in contract documents, and if not carefully drafted, can result in multiple disputes as to which insurer is required to defend which insured. Construction contract language should be designed to avoid such disputes. For example, a short-form contract might require that, quote, the contractor shall maintain liability insurance to cover any damages to the owner's property and the property of third parties, or the bodily injury of third parties resulting out of the acts of the contractor, and provide a certificate of insurance to the owner listing the owner as a certificate holder and as an additional insured. The contractor shall provide the owner with a copy of the additional insured endorsement, the full policy issued by the contractor's insurer naming the owner as an additional insured, and agrees to immediately advise the owner of any changes in the policy. This language was prepared by me as an example and not as a recommendation. It was adapted from various contracts. It is not intended as legal advice, and the reader or listener should consult with competent counsel before using any particular language in a contract. In that regard, note Mid-Continent Casualty versus Swift Energy Company, a 2000 decision of the Fifth Circuit Court of Appeal, where multiple parties and insurers argued interminably over who was entitled to indemnity under an additional insured provision. The court found the clauses ambiguous and required indemnity to be paid on behalf of the additional insured. An owner and a contractor should make every effort to obtain language in their contract forms that will avoid ambiguous additional insured endorsements. The form language in the example above includes a requirement that the contractor provide the owner with a certificate, a copy of the actual endorsement making the owner an additional insured, and a copy of the entire policy. An owner who receives an endorsement should read it carefully, and if it is not clear, then the owner should demand that it be clarified. A typical additional insured endorsement will provide, quote, in consideration of the premium charged you, we agree that the person or entity listed below is added as an additional insured. This endorsement applies only with regard to occurrences resulting from your, the named insured's operations. This endorsement does not apply, and the person or entity listed below is not an additional insured if liability is claimed or found to be due to the sole negligence of the person or an entity named as an additional insured. Claim or suit is brought by your employees, officers, directors, or partners, employees, officers, directors of your subcontractors or independent contractors, or employees, officers, directors, or partners of the additional insured. You and we expect and intend that such employees, officers, directors, joint venturers, or partners will be insured under the applicable workers' compensation laws of the state where the work is performed. Close quote. A contract dealing with construction needs to establish the duties of the various parties to the contract of insurance. For example, quote, the contractor shall purchase from and maintain in a company or companies lawfully authorized to do business in the jurisdiction in which the project is located such insurance as will protect the contractor from claims set forth below, which may arise out of or result from the contractor's operations under the contract, and for which the contractor may be legally liable, whether such operations be by the contractor or by a subcontractor or by anyone directly or indirectly employed by any of them, or by anyone whose acts any of them may be liable. This is from an AIA document. These include, among other things, insurance that protects against claims for benefits under workers' compensation laws, benefits for disability or other similar employee benefit plans, claims for damages because of bodily injury, occupational sickness or disease, or death of the contractor's employees, claims for damages other than to the work itself because of injury to or destruction of tangible property, including loss of use resulting therefrom, claims for damages because of bodily injury, death of a person, or property damage arising out of ownership, maintenance, or use of a motor vehicle, claims for bodily injury or property damage arising out of completed operations, and claims involving contractual liability insurance applicable to the contractor's obligations under the contract. The requirements are usually verified by the contractor, providing to the owner, architect, and others a certificate of insurance, that is, a statement by an insurance agent or broker that insurance exists at the time the certificate is signed in the amount stated in the certificate by the insurer's representative. A certificate of insurance is not insurance, but only evidence of insurance at a specific time. Certificates often promise to advise the certificate holder if the policy is canceled or otherwise goes out of force. Liability insurance policies that will defend or indemnify an insured from claims of construction defect change with great regularity, and the lawyers for the parties seeking such insurance should make sure that their demands for insurance from a contractor or subcontractor names current and effective forms of insurance. Some commercial general liability insurance contracts contain an endorsement or a clause that provides automatic additional insured provision and coverage for any written contract executed by the named insured that promises to make the owner or others additional insureds, without the need for a specific endorsement stating that the owner of the project or the contractor, whoever is part of the agreement, is named as an additional insured. It is essential that those requirements be in the contract with the parties, or there will not be additional insured coverage. And it is also essential that the person purchasing the insurance understand that there is a broad form additional insured provision in the policy, making everyone who demands in writing that the named insured make them an additional insured will be an additional insured. Many, in fact, most construction contracts also contain a waiver of subrogation. These are contract terms that ought to require that the parties to the contract waive their insurer's rights of subrogation, which is usually provided for in a contract of insurance that allows for waiver of subrogation if done so before a loss. These clauses will provide, quote, to the extent damages are covered by project management protective liability insurance, the owner, contractor, and architect waive all rights against each other for damages, except such rights as they may have to the proceeds of such insurance. The policy shall provide for such waivers of subrogation by endorsement or otherwise. You must understand that not all contracts of insurance allow for a waiver of subrogation, which means it is necessary to read your insurance policy before agreeing in a contract to a waiver of subrogation, because by doing so you are breaching the insurance contract and depriving the insurer of a benefit that the contract of insurance requires. The language can also provide, quote, the owner and the contractor waive all rights their insurers have to subrogate against the owner or the contractor to the extent that any loss is covered by valid and collectible insurance if the construction project is destroyed or damaged by accident, disaster, or calamity such as fire, storm, flood, landslide, subsidence, or earthquake, work done by the contractor in rebuilding or restoring the project shall be mutually agreed upon by the owner and the contractor before the start of work, and the owner and contractor shall ascertain their respective insurers approve and authorize the waiver of the right of subrogation. More reason why, in addition to reading all of the words of the construction contract, it is essential that the person engaged in such a contract also read all of the words of the insurance policy to make sure that that policy is providing the protection that is desired. Parties to such contracts that do not carefully review their insurance contracts may find they are in financial difficulty. For example, failure to obtain permission to waive subrogation can void the insurance contract, as was held by the California Court of Appeals in Liberty Mutual versus Alt Village, a 1977 decision, where the court held that the waiver was clearly a breach of the insured's implied covenant of good faith and fair dealing. Material breach of policy provisions by an insured relieves the insurer of liability upon at least a showing of prejudice, and sometimes the prejudice is not required. This video was adapted from my book, Construction Defects and Insurance, Volume 1, which is a first volume of the 8-volume treatise, Construction Defects and Insurance, available as both a paperback and a Kindle book from Amazon.com. If you found this video to be interesting or useful to you, please forward it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. Thank you for your attention.